Also, please give warm welcome to our special guest, an idol of knowledge with experience and inspiration to all of us, Mr. Abu Muhammad Aminuddin, Attorney General, the Government of the People's Republic of Bangladesh, and Mr. Aminul Islam Amin, Deputy Press and Publicity Secretary, Bangladesh Awami League. Thank you to all of our honorable guests for joining our seminar today. And later, our chief guest, Honorable Mr. Minister Dr. Hassan Mahmood, Minister of Information and Broadcasting, the Government of the People's Republic of Bangladesh, will be joined with us virtually. And now, we will start today's seminar, Fact and Impact of Digital Bangladesh Act 2018, organized by diplomats and powered by Sultan EMS, with Sheikh Mohammad Fazul Mubin sir, the Managing Director of Sultan EMS and Associate Editor of Diplomats World Publication. Please, sir, come on the stage and start our program. Please put your hands together.
Assalamu alaikum. I would like to take you back 1993 when internet first came in Bangladesh. Then, if you see in the year 2006, we have got our submarine cable. Then, in 2010, our total internet user in Bangladesh was 5.6 million. And we talk about 2016, we have got 117 IPS license holder under whom there were 2 crore internet user by Wi-Fi. And when you see 2020, you see the total internet user more than 100 million, 10 million. Now, if we go the status of social media, we can see the difference. When we started Facebook back 2009, there was only 56,000 users in Bangladesh. Now it is more than 4.5 million. We talk about Instagram, we talk about Twitter, YouTube. There are significant number of people increases in digital platform. We talk about the devices that we use now. Most of the people we use mobile phone. The number of smart television, smart devices increases in our life. And then we see our life. You can have a look. We go for any payment, we use digital platform. We go for any meeting, conference, we use digital platform. We want social corresponding, we use social media. For information, we have newses. In every aspect of life, there is digital footprint around our society. From here, we also witness the crime that roam in digital platform. There are various kind of cyber crime. So what do you think? When there were only few thousand people who were used to be in internet or digital platform, now it is few crore. So don't you think that there should be a law or there should be a legal platform that address the crime, that secure the safety of the people who are roaming in this digital platform? So on this context, Diplomat World organizing this program, Facts and Impacts of Digital Security Act. So I am Sheikh Mohammad Fazul Mubin, Managing Director of Celtron. Welcome you all in this seminar. Our honorable chief guest, respected chairperson, respected special guest and dignified keynote speaker, audience present here, and my dear journalist. I would like to welcome you all in this seminar with a small short video. Thank you.
With a vision to join the global digital uprising, Bangladesh has become Digital Bangladesh. Now, communication is faster. Access to facilities is easier to avail. Lifestyle has become diversified than before. Meanwhile, security risks in cyberspace have multiplied. Online privacy is facing severe threats. Information and data smuggling is raising concern. To brace the uprising of cyber crimes, the government of Bangladesh has enacted Digital Security Act 2018. But some falsified claims and misinterpretation criticized and branded this act undemocratic and hampering its true purpose. To highlight the positive impacts of the act, compare the act with other international acts, and assess its relevance in digital Bangladesh, Diplomats World is presenting Fact and Impact of Digital Security Act 2018. Together we shall ensure a mutually beneficial national digital security.
Thank you, sir, for your valuable speech. Now I would like to request our keynote speaker for this seminar, Barrister S.M. Saifullah Rahman, IT and regulatory laws expert, for presenting and discussion on crime to individual.
Bismillahirrahmanirrahim. Assalamu alaikum wa rahmatullahi wa barakatuhu. Good afternoon and greetings, everyone. On this glorious afternoon, I'd like to begin my keynote speech today by extending my heartfelt gratitude towards today's organizers, Diplomats World Publications and Celtron EMS, for arranging such a beautiful and livid event on a very significant topic surrounding the Digital Security Act 2018, which purports to shed some light on the darkness surrounding our ever-expanding digital world. Firstly, I would like to send my humble greetings and regards for our honorable chief guest today, an invaluable member of this ruling government's cabinet, and a resonant voice in support of the progressive developments and growth on behalf of our beloved nation, Dr. Hassan Mahmood MP, Honorable Minister for Information and Broadcasting. Next, I would like to extend my humble greetings and regards for the Honorable Chairperson of today's event, an icon for the youth, a beacon of excellence and an inspiration for the youth of tomorrow. And I must add, he is an integral driving force behind the digitalization of this golden nation. Mr. Zunaid Ahmed Palok MP, Honorable State Minister for Information, Communications and Technology. I would also like to extend my heartfelt gratitude for the honorable special guests today. One of my mentors and a legend of the lawyer community, Mr. Abu Muhammad Aminuddin, Honorable Attorney General for Bangladesh. I would also like to extend my special greetings and regards for another special guest, a favorite personality, Mr. Muhammad Aminul Islam Amin, Honorable Deputy Press and Publicity Secretary of Bangladesh Awami League. I would like to extend my greetings for fellow honorable keynote speakers, my very favorite legal personality, Mr. Barrister Ali Asif Khan, and another very important keynote speaker, Professor Mr. Hafizur Rahman Karzon, Law Professor, Dhaka University. I would also like to extend my greetings and regards for every honorable guests and dignitaries present today, representatives from the media who've all taken time out of their busy schedule in the middle of this week to address an issue which is growing as a mega concern with each passing day for the youth, the society, and today's generation alike. I'd like to begin my speech today by stressing the importance of the digital and technological advancements in our lives today. In this age of digitalization, it is undeniable that people from every corner of our country are using technology in some form or manner. People in the farthest and the most remote areas of this country have access to this magnificent and ever-fascinating digital world, which was beyond the realms of our wildest imagination only but a decade ago. If you look at some of the statistics, As already mentioned by Mr. Mubin, we can see that from about our total population of more than 170 million, at least 12.1 crores or 120 million are using internet directly or are within the perimeters of the digital devices in the cyber world. And among such numbers, Mr. Mubin has also mentioned that more than 50 million people are using social media actively to connect and rejoice in the world of virtual reality and connectivity. If you look at just the last year of the COVID-stricken times, we see a significant surge in digital platforms usages, having 25% increase in social media usages and over 20% increase in digital and internet platforms. So this global pandemic has allowed us to digest one fact, and that is this digital world is not an extra or hypothetical reality, but only a parallel and ever-existing reality. Scrolling in Facebook is now the same as taking a walk in the open streets. Therefore, the same rules of law and order must apply to the engagement and presence of a person in social media. The same etiquettes and mannerisms must also be involved. Now, in the wake of this great digital movement, we are yet to experience some of its biggest blows. The country under the leadership of Bangladesh Awami League have experienced the highest growth in information technology, and this will definitely have its proportionate repercussions. Therefore, the need for just the right form of legislation to address crimes conducted in digital platforms became imminent and of national importance. Now, it is also imperative to note the position before the Digital Security Act, which was the much controversial ICT Act of 2006, with its Section 53 being the headache and core concern for most national and international human rights watch, and it craved media attention every now and then, and for all the wrong reasons. Now, with this heavy increase in our venture along the path of digitalization came grounds for illegal offenses and many crimes, along with its countless benefits. Let us look at some of the statistics concerning crime against individuals which have risen as a result of increase in digital platforms usage. So if we look at this crime statistics, it clearly shows that 80% of girls in Bangladesh are subjected to some forms of online harassment, cyberbullying, or some form of defamations or controversies at some point in their life. Incidences of offenses such as hacking, stealing information, and online financial crimes such as ATM card hacking, online payment fraud, such as bKash fraud, have increased alarmingly in the last couple of years, as reported by the Cybercrime Awareness Foundation. Also, there are incidences of other online accounts hacking, such as Facebook accounts hostages, which has grown by more than 10% and is now at 26.31%. Now, I would like to draw the attention of everyone towards the presentation. Now, what is interesting is that the victims of cybercrime is within the age groups of 18 to 30. And what is more interesting is that the persons or the people who are committing the cybercrime are also within the same age group of 18 to 30. Now, in order to address all of these crimes came the Digital Security Act 2018 from our lawmakers, which, far from being the most perfect act, purported to address several vital issues and provided offenses, identifying crimes which lay shrouded in darkness, being impossible for most of us to perceive. Now, through the enactment of this Digital Security Act, Bangladesh has stepped into the data and information protection for the first time since its inception. Now, if we look at the primary legislation, it would show that the Penal Code of 1860 does not cover stealing of information, and that has been the position in the persuasive common law. For instance, for centuries, this has been the case, as we see in several laws and precedents of various jurisdictions. Even in the very renowned British principle laid down in Oxford versus Moss, it states that information cannot be stolen. However, through the provisions of the Digital Security Act, the government ensures protection of information. which was fundamental and clinically essential to individual privacy and protection of interests. For instance, if we look at Section 26 of the Digital Security Act 2018, we see that an individual's explicit consent or authorization is required for the collecting, selling, storing, preserving, supplying, or using his or her identity information. Now, this provision will have widespread impact in our country's forthcoming digital economy. For example, in fields such as telecommunication, e-commerce, banking, and fintech industries, where organizations will now be bound to protect customer information and will not be able to use any data-related information without explicit consent or authorization. Now, as this section appears to interpret consent or authorization very strictly, therefore, it means that without this consent, or where the consent is withdrawn, information or personal data of a person cannot be used or processed in any manner, and this has only made a person's life more protective and secured. Now, let us take a look at some of the other provisions of the Act, which clearly has similar protective provisions. Right. So before I draw the attention of everyone to the provisions of this Act, I would like to say a few more things. Now, for example, if we look at a particular class of people who are most affected by cybercrime, that would be women. I'm sure we can all agree. Now, for women, we can see that the cybercrimes committed against them have turned to a very detrimental extent, causing havoc at a massive scale. If you look at some of the reports of the Ain and Shalish Kendro, we see 80% of these female are between the age groups of 18 to 22 who are suffering from some form of cyberbullying, online harassment, or some form of defamation controversies online. We've seen only in the year 2020, till October 2020 in fact, more than 17,000 complaints have been made by women to the law enforcement agencies. And from them, 12,000 have been addressed and only 8,000 have formally turned into official complaints. We've seen statistics from representations of Bangladesh Mohila Ainjibi Committee who've stated that these online social media defamation and controversies have caused several number of females to resort to extreme measures such as death and suicide. Now, to combat such heinous acts of crime, the government has published these provisions. For example, if we look at Section 17, we see the government punishing for illegal access to critical information infrastructure. We see in Section 18, the government has provided punishment for illegal access to someone else's computer, digital devices, computer system, etc. We can also see if you look at Section 25, the government has provided punishment for the transmission, publication of defamatory information, as well as offensive, false, or threatening data information, which anyone may use in order to annoy, insult, humiliate, or malign a person, or publishes or bids to publish them. Now, I would like to draw the attention of everyone to an interesting provision, which is Section 29 of this Act. This provides punishment for defamatory information. Now, this must be mentioned that this Section 29 is a groundbreaking provision. Why? Because it covers defamation or harassment through digital means. Now, in this regard, before, the primary legislation being the Penal Code 1860 did not cover harassment or defamation by digital means. This penal code also follows Evidence Act 1872 in respect of taking evidences. Now, we all know, or many of us know, that as per the Evidence Act, currently evidence through digital methods is not recognized, whereas defamation under the Digital Security Act gives remedy to the defamation caused on digital platforms. However, I would also like to draw the attention of lawmakers to the fact that specific rules governing admissibility of these digital or electronic evidences is yet to be clearly defined. Now, as for the cyber laws, in contrast and comparison with the more developed world, it is also the case that there are still some life-threatening crimes that are not addressed in our current statutes. dangerous crimes such as cyber stalking, morphing have not been clearly defined explicitly within our laws. These gives some gaps which the opportunists exploit. Now, for this reason, the situation regarding cybercrime is taking a negative turn. However, apart from certain small flaws, it is undeniable that this act is armed and equipped with very important and landmark provisions to protect individuals against cybercrime. Yet, there must be certain scrutiny put into the judicial enforcement of the act. Now, when we look at certain research, we see that from 1,692 cases in trial as of now, around 400 have received verdict, and from them, only 29 went on to be convicted, which is less than 2% of the cases going to courts, ultimately getting a conviction. Now, this ultimately makes the culprits feel immune and commit more crimes. Therefore, in the coming years, with increased scrutiny of the Act and more focus on the enforcement of its already provided well-equipped provisions, there is a chance that the conviction rates will go higher. And it is also safe to say that the Digital Security Act 2018 can be a landmark act that brings us in tune with the integrity and legal protection of the more developed world. Therefore, in concluding, it is humbly stated that we must welcome and applaud the positive impacts that the Act has brought into our legal system. It is undeniable that we must rise above the criticisms to positively state that our civil rights and national security have been much protected thanks to the Act. It is also humbly urged that while criticizing of any legal statute or legislation is warmly welcomed, that is something that we must do. However, we must not go beyond the boundaries of misinterpretation to create widespread confusion about a very useful instrument that it verily does not deserve. Thank you for your patience. Signing off, Barrister S.M. Saifulur Rahman. Thank you.
Thank you, sir, for your presentation, and let us know more about crime to individual regarding digital security of Bangladesh. Now I would like to request our second keynote speaker, Barrister Ali Asif Khan Rajib, Advocate of the Appellate and High Court Division, Supreme Court Bangladesh, for his discussion on crime to society.
Assalamu alaikum. My most respectful greetings and regards to the esteemed chief guest, Dr. Hassan Mahmood MP, the Honorable Minister for Information and Broadcasting, our Honorable Chairperson, Mr. Zunad Ahmed Polok MP, the Honorable State Minister for Information and Communication Technology, ICT, our special guest, Mr. A.M. Aminuddin, the Honorable Attorney General of Bangladesh, and Mr. Aminul Islam Amin, Deputy Press and Publicity Secretary of Bangladesh Awami League. I also extend my greetings to my fellow keynote speakers who have just spoken right now, Mr. Barrister S.M. Saifulur Rahman, Mr. Sheikh Hafizur Rahman Karzon, Professor and Faculty of Law, Dhaka University. Distinguished guests, ladies and gentlemen, a very good afternoon to all of you. It is indeed a great honor and privilege for me to be a part of this prestigious event, and I would like to thank the organizers, the Diplomats World and Celtron, for inviting me to speak at this session. Today's topic is undoubtedly one of the most debated legal issues in our country right now, the Digital Security Act of 2018. Despite being a fairly new legislation, it has already sparked some debate and controversy associated with many disputes and stigmas. Any matter related to this law is now approached with prejudice and suspicion. I'm glad that today's seminar is giving us the opportunity to truly understand the importance and function of this act. As you all know, Bangladesh is home to 120 million internet subscribers, accounting for approximately more or less 53% of its entire population. The contemporary legal framework based on which this particular act, the DSA, came into force was in fact embedded in the Information Technology Act of 2006, which was largely held to be insufficient in terms of addressing digital security and data protection concerns. Consequently, Bangladesh has taken steps to improve its digital security framework through its e-governance project and Digital Bangladesh vision envisioned by our Honorable Prime Minister Sheikh Hasina. Furthermore, the government formulated a national cyber security strategy charting a vision for cybersecurity for 2021 and beyond. As a result, Bangladesh enacted the Digital Security Act 2018 on September 2018, passed with the objective of curbing cyber crimes and related offenses. This legislation, although new and requires judicial development, is a comprehensive law that deals with offenses committed on digital platform in Bangladesh. As you all know, the traditional legal structure for criminal offenses is mainly governed by the Penal Code of 1860, which is still insufficient and does not cover most of the modern offenses committed on digital and online platform by way of breach of data protection, cyberbullying, and many more. This act provides a safe harbor protection for intermediaries and penalizes illegal use of digital network mediums. The most important sections in this act are often overlooked. Those sections safeguard fundamental rights and interest of both the citizens and the government. It is designed to serve many purposes, and one of those purposes is to protect the society by at large. So let's start with the first provision, which I have summarized, that is section 17. Can we have the slide, please? I apologize, there might be a technical issues with the slide. Anyways, let me go forward without wasting time. So the first section is section 17 of the Act, which protects critical information infrastructure maintained by the government. So in simpler terms, critical information infrastructure refers to information not only like national ID details or passport details. Sooner or later, it will also include those infrastructure that will primarily govern our power supplies, our transportation, so on and so forth. So a punishment is there for anyone who breaches those systems, hacks into it, and causes loss of property, loss of right, and loss to the government infrastructure, which pertains to our national security as well. This section penalizes illegal access and harm caused to such infrastructure. The maximum custodial sentence for this offense can even extend up to life imprisonment. The court also has the power to impose fines up to the tune of 5 crore taka. The punishment under this section are meant to have a strong deterrent effect on the potential offenders. The judicial effectiveness of this law is yet to be discovered because we don't have any precedent right now regarding this sort of offenses under section 17 yet. Nevertheless, this section is prime example of how the Digital Security Act can be used to curb offenses that can affect the society as a whole. Another crucial offense under this act deals with cyberbullying under section 25. It is An act is a bullying act with use of digital technology, which takes place on social media or through messaging platform, mobile services, gaming platforms, etc. Cyberbullying includes spreading lies about or posting embarrassing photos of someone on social media, sending hurtful messages through SMS or emails or threads of via messaging platform like WhatsApp, Vibers, etc., impersonating someone and sending mean messages to others on their behalf. Face-to-face bullying and cyberbullying can often happen alongside with each other without the person knowing that it is happening. However, cyberbullying leaves a digital footprint, a record that can be proven useful when giving evidence in court and provide enough help to stop the abuse. Cyberbullying and online character assassination have emerged at an alarming rate in recent times, especially against women and children, more so with the marked increase in time spent on the internet by youth during the pandemic. So if we look at to section 25, so this is the provision for your reference. Section 25 of the Act criminalizes the act of sending or publishing false or offensive information to humiliate or tarnish the dignity of the nation or spread confusion by using any digital medium. Such an offense is punishable by a maximum imprisonment of 5 years and a maximum fine of 10 lakh taka, which means that people now have a cause of action against an individual if he or she is being bullied as a victim by another person on a digital platform. The most common form of antisocial behavior on online platform is criminalized through this provision. Another example is section 28, which seeks to protect the religious sentiment and values of people from being unlawfully hurt. It prohibits the malicious publication and broadcasting of materials that will provoke or hurt religious sentiment, as we have seen in most recent times during the last Durga Puja event. Almost 100% of the Bangladeshi population associate themselves with some sort of faith or religious belief. Essentially, it means that the ideology and belief system of Bangladeshi citizens are very much reliant upon their religion. Given how sensitive and emotional the subject is, provoking such sentiment may, along with risking the safety of the individual, also jeopardize the communal harmony of our society. This section is a legislative attempt to protect the religious sentiment of people from being unduly compromised. However, this provision is not clear as to how the freedom of speech on an individual should be balanced against the protection of religious sentiment. People in our country, as of their constitutional right, has the freedom to engage into constructive dialogues on religion. It may even be the case where an individual is offended from slightest constructive arguments made against religious practices. In such circumstances, the court should provide judicial guidelines and set a boundary to what may or may not constitute a breach of this section, and to what extent a statement may be considered as a hurtful religious message to the people. With the much needed guideline from court, this provision will also be effective when serving to benefit the society at large. Now, the most interesting part, the most controversial part of the statute, the DSA, which is already being debated upon by both within the national and international spectrum, that is section 21. In my opinion, section 21 is widely misunderstood, and I will briefly explain as to why. Let me read out the provision first for your convenience. Section 21 of the Digital Security Act of 2018 deals with punishment for making any kind of propaganda or campaign against liberation war, the spirit of liberation war, the father of the nation, our national anthem, and our national flag. This provision prohibits propagating and campaigning against the national flag, our anthem, our father of the nation, the spirit of liberation war, and the liberation war itself. I will strongly argue that this section is designed to protect the integrity of our constitution and the legal structure of Bangladesh, and thereby uphold the collective interest of the citizen. So before we dive into it, let me go back to the preamble of the Constitution of the People's Republic of Bangladesh. Can we have the preamble slide, please? Next. Yes. So as you can see, the preamble of the Constitution of People's Republic of Bangladesh reads as follows: pledging that the high ideals of nationalism, socialism, democracy, and secularism, which inspired our heroic people to dedicate themselves to, and our brave martyrs to sacrifice their lives in the national liberation struggle, shall be the fundamental principles of the Constitution. So the key word is fundamental principle. Then Article 8 of Part 2 of our Constitution further states nationalism, socialism, democracy, and secularism to be the fundamental state policy of People's Republic of Bangladesh. And Article 9 of our Constitution specifically defines what nationalism means. So the term nationalism has been defined as Bengali nationalism. And if we can have slide for Article 9, yes, that's the one. The unity, I'm reading out from the article of our Constitution. Article 9 defines nationalism as the unity and solidarity of the Bengali nation, which deriving its identity from its language, culture, attained sovereign and independent Bangladesh through a united and determined struggle in the war of independence, shall be the basis of Bengali nationalism. So, our father of the nation, the greatest Bengali ever lived in 1,000 years, Bangabandhu Sheikh Mujibur Rahman. He is the physical embodiment of Bangladesh. He is the physical embodiment of our liberation war, of our struggle, and in turn, the independence of Bangladesh. So, to propagate against him, to propagate against our nationalism, is to propagate against our constitution, the very existence of the People's Republic of Bangladesh, and also to propagate against the people of Bangladesh. So this what section 21 of the DSA does. It protects our constitutional boundaries, our parameters, the fundamental principle based on which the People's Republic of Bangladesh was founded upon. So it protects the founding father, our father of the nation, Bangabandhu Sheikh Mujibur Rahman. It protects the spirit of our liberation war. I must mention that Bangladesh is not an exception or a single nation to uphold its nationalistic ideologies through legislations. The same approach has been adopted by our neighboring nation like India through their own Prevention of Insult to National Honor Act 1971, and the state of Tamil Nadu also has their own law, which is called the National Honor Act of 1957. It's the National Honor Act 1957 together with the National Honor Act of 1971 specifically criminalizes action which demean the national flag of India, the Constitution of India, the national anthem of India, and even if someone prevents a person from singing their national anthem. And the National Honor Act of 1957 penalize the act of insulting the national flag, the Constitution, and their founding father, Mahatma Gandhi. Moreover, in Turkey, under Article 301 of the Turkish Penal Code, It's an offense for insulting the Turkish nation, the people of Turkey, its national heroes, including its founding father, Mustafa Kemal Atatürk. Such laws are also present in the developed Western countries. For instance, the Treason Felony Act of 1848 in the United Kingdom is still in effect. You can check, you can Google it. This act makes it an offense to advocate for abolition of monarchy. So whoever advocates, propagates, or campaigns in favor of the abolition is considered an accused under this particular law, and such advocacy is punishable by life imprisonment. Now let's come to the so-called big ones. The propagator of democracy, the United States. The US Code under Title 18, Chapter 33, Section 700 makes it illegal to insult the flag of US. So the reason why I'm mentioning all these laws is not to strike a comparison between all these legislation, but just to demonstrate that Bangladesh is no exception. Bangladesh, like any other nation, has passed legislation to protect its own identity, to protect its sovereignty, to protect its constitution and the spirit, the founding spirit based on which Bangladesh was founded. Section 21 of the Digital Security Act is not an undemocratic provision, rather a provision which seeks to protect the essence of democracy itself, that is concerned with nationalism. The question may then arise, what about this section is so controversial? This provision has been accused of being unconstitutional and restrict freedom of speech. I have already explained it, how it is in line with our constitutional principles and how it actually promotes our constitutional principle of nationalism and other related provisions. However, a prime question is, does this provision limit freedom of speech? The answer is yes and no at the same time. It does not, this section does not arbitrarily restrict the freedom of speech. Now, the freedom of speech is guaranteed under Article 39 of our Constitution. So, I will just read out the particular provision. But let me remind you, Article 39, the freedom of speech, is not an absolute right. It's a qualified right, which means the state can impose certain restrictions and certain conditions. So let me read out Article 39, Part 3 of our Constitution. Freedom of thought and conscience and of speech. 39.1, freedom of thought and conscience is guaranteed. 39.2, subject to any reasonable restrictions imposed by law, in the interest of the security of the state, comma, friendly relation with the foreign states, comma, public order, comma, decency or morality. So, I have right to speak freely, the way I like, but my right is a qualified right in a sense that the state can enact law or legislation which can limit such freedom of speech. I cannot say whatever I want to say. So there are certain restrictions. However, I'm not suggesting that this law cannot be enforced in an unconstitutional manner. The problem is not the law. The problem is enforcement. So what we need to do, we need to train our enforcers, the law enforcing agencies, as to how to go about making investigation, conducting investigation. We need to train the IOs who will be in charge or who is in charge to investigate the offenses under Section 21 or any other section. So the judiciary plays a key part because this is a new act. We haven't gone to the Supreme Court yet for interpretation because the lawmaker here, Parliament makes law. It is the responsibility of the judiciary to interpret those legislation. To what extent certain action is allowed, whether the action is justified legally or not, what sort of evidence do I need to prove my case. These are all matter for the judiciary to decide. So the judiciary would decide whether the enforcement was within the legal jurisdiction and whether due compliance was followed, and all legal processes have been exhausted in investigating the crimes or offenses under the Act. Further, one must not forget that exercise of freedom of speech or expression under Article 39 does not allow a free rein on the electronic or print media or social media. My exercise of freedom of speech must not under any circumstances violate or invade the rights guaranteed under Article 43 of the Constitution, which in effect guarantees my right to privacy and my protection of my private life. The Digital Security Act is a very new concept to our society, and the executives, along with all other organs of the country, are adopting with the constantly changing social and technological demands. With requisite training to the enforcement agencies and judicial activism on dealing with cybercrime, the enforcement of this law will come more in line with the spirit of our Constitution. As an effect, this law shall also operate to the best interest of our society. There are more provisions in the Digital Security Act that protects the interest of the citizens and the nation in the digital platform. And due to limitation of time, I have only mentioned few of those, and now I will cut short my speech and finish here. Thank you everyone for your patience. Thank you for coming here, taking the time. Thank you so much. Joy Bangla, Joy Bangabandhu.
Thank you, sir, for your valuable speech. Now I humbly invite another keynote speaker, Mr. Sheikh Hafizur Rahman Karjan, Professor, Faculty of Law, the University of Dhaka, for his discussion on freedom of speech. Thank you, sir.
Honorable Chair, Honorable State Minister of ICT Division, Junaid Ahmed Polok, Honorable Chief Guest of this seminar, Mr. Hassan Mahmood MP, Minister, Ministry of Information and Broadcasting, Honorable Attorney General, my very favorite Aminul Islam, and other honorable keynote speakers and respected audience. My salam and good wishes to all. And the topic on which I have to speak, that is freedom of speech. And this is on very important human rights. And you know that modern democracy and modern open society, they put huge importance on human rights. And the human rights which we discuss in our public universities, in advanced institutions, you know that these human rights, they are outcome of unprecedented landmark events in the whole world. We are getting these human rights from French Revolution, from independence of America, Declaration of Independence of America, and democratic movements of Britain. And one of the very important civil and political rights, we know that is freedom of speech. Now, I have to discuss whether the Digital Security Act, what is the relationship between this freedom of speech and Digital Security Act? And there are many, many national and international stakeholders and many organizations, they are criticizing whether this particular legislation, Digital Security Act, has curtailed the ambit of freedom of speech. And you know that the core article in respect of freedom of speech, that is Article 39. And my previous keynote speaker, he has a bit discussed about this. And you will notice that this Article 39, it has two parts. First part 31, Article 31.1 guarantees the freedom of thought and conscience. And this right is given in absolute form because it is not possible to put any restriction on thought and conscience. Because what we are thinking and what moral values we are bearing, it is not possible to put any restriction. What I am thinking, it is not possible to know for any other person. Or what is the conscience? If I write anything in my diary, or if I think anything if I develop any ideas, it is not possible to put any restriction. But if you have to look at Article 39.2, because it is not absolute. And it is said that we see from the French Revolution, from the democratic movement of United States of America, UK, we have developed many civil and political rights. And after the Second World War, the international community, from the nightmarish experience of Second World War, they thought that we have to do something for the protection and preservation of human rights. That's why we have seen within 5 years the development of the establishment of United Nations, the adoption of Genocide Convention, the adoption of Universal Declaration of Human Rights, the adoption of 4 ICRC Convention in 1949. And all these events, they contributed to the development of international human rights law, international humanitarian law, international criminal law. And when we are discussing human rights, we have these inherent and inalienable rights, but these rights are not absolute. You are not supposed to do whatever you like. So these civil and political rights and also these fundamental human rights, they are guaranteed in the Constitution of Bangladesh, but subject to reasonable restriction. And you have to see, you have to look at Article 39.2, guarantees the freedom of speech and expression, but subject to restriction, reasonable restriction, which a state can do by law. And these are the grounds on which a restriction could be put in the interest of the security of the state. You are not supposed to say anything. You are not supposed to write anything which will go against the sovereignty of Bangladesh. Friendly relation with foreign state. You should not express your freedom in that manner which will harm the friendly relation of Bangladesh with any other neighboring state or any other country. Public order or decency or morality or in relation to the contempt of court, defamation or incitement to an offense. So human rights, when we are talking about freedom of speech or anything, freedom of religion, freedom of assembly, freedom of association, all these rights are not absolute because a state can put reasonable restriction by law for public morality, for decency, for stability of the society. So if after mentioning this second part of Article 39.2, if we look at the preamble of Digital Security Act, then we understand what has been stated as to the objectives, because we know with the students of law we know that the objective of any law, it is stated in the preamble of any particular law. So if I read the preamble of the Digital Security Act, an act to make provision for ensuring Digital Security Act and identification, prevention, suppression and trial of offences committed through digital device and for matters ancillary thereto. So we know that by this time we have developed cyberspace, we have developed huge number of, there are huge number of internet users, huge number of smartphone users, and we see e-commerce and many government and non-government institutions, they are using internet and computer for different purposes. So if I look at the many statistics data have been given by my previous keynote speakers, I am looking at the statistics given by BTRC. The total number of internet subscribers has reached more than 11 crore, 112.713 million at the end of January 2021. And now more than 171.85 million people, they are using different types of phone. And also I mentioned that we have developed e-commerce, and many national and nearly government and non-government institutions, they are using computer and internet for different purposes. So because of this new reality, we have to, it is necessary for the state to ensure the security of the digital space. And that's why Digital Security Act has been enacted. So I would like to congratulate the government to enact this law in 2018 to ensure the security of the digital space. But at the same time, I would like to say different national and international organizations, they are putting their criticism as to some aspect of this law. Say, for example, some section of this Digital Security Act, they are non-bailable. Number two, some key definitions of this law, it is very vague and wide. Thirdly, the punishment imposed in this law in different sections, that is huge. So I think the necessity of law, because all the stakeholders, all the people, all the experts, they are saying that there is no controversy about the necessity of enactment of this law. But there are some disagreement or criticism as to, as I have said, as to the definition, as to the some section, non-bailable section, and some punishment, amount of punishment, extent of punishment imposed by this law. So I think government can review this, because we have seen the International Crimes Tribunal Act 1973, it was amended in 2013. And also another law, Honorable Minister, he is saying that Nirapod Shorok Ain jeta, that can be reviewed. So my submission is that freedom of thought and conscience, it is very, very important. And modern world, modern democracy, open society, they put huge emphasis on this freedom of expression. But freedom of expression or freedom of speech, it is not absolute. It could be curtailed, it could be, government can impose restriction on reasonable ground, but that must be done within the parameter of the constitutional norms. And lastly, I would like to say the Constitution, Bangabandhu Sheikh Mujibur Rahman, he is the father of nation of Bangladesh, and under his leadership, after 24-year-long struggle, we established independent Bangladesh, and within 1 year, we adopted our constitution. And you will find the objective of this Bangladesh in at paragraph 3 of Bangladesh, preamble of Bangladesh Constitution. And paragraph 3 of preamble of Bangladesh Constitution states that the objective of this state is to establish socialist society. It's not a state. Objective of this Bangladesh is to establish socialist society through democratic means, where there will be rule of law, where there will be fundamental rights, where there will be justice, and this justice has been qualified. Political justice, economic justice, and social justice. That is the ultimate goal, and that is Bangabandhu Sheikh Mujibur Rahman and other founding fathers who established Bangladesh. That's why they established this Bangladesh. And if we want to achieve that goals, then we have to work together and we have to do whatever will be needed. So at last, I would like to convey my thanks to the who have organized this seminar, Diplomats Word Publication, because it's true that there are some misconceptions, there are some controversies as to this Digital Security Act. And because of this seminar, the misconception and controversies and other misunderstanding will be eliminated. And I would like to congratulate Diplomats World Publications for organizing this seminar, and also give me an opportunity to say in this seminar. So my heartiest gratitude to this organization and all the dignitaries. Assalamu alaikum.
Thank you, sir, for your enlightening speech. Now I would like to invite our special guest, Mr. Aminul Islam Amin, Press and Deputy Secretary, Bangladesh Awami League, for his speech.
Assalamu alaikum. Very good afternoon. Honorable Chair and the Honorable Chief Guest, our Minister, Dr. Hassan Mahmood, and Honorable Chair, Jonathan Ahmed Pollock MP, and other all distinguished guests. I would like to convey my salam and respect to you all. Actually, I don't have any preparation to deliver my speech here because last few days I was in hectic political program, busy with that all things. And when I came here, Mr. Mubin asked me to deliver my speech. So I would like to say here very shortly. That is very much clear. We cannot avoid the reality of the world. And many reality prevailing over the world. One is this social media. And for this reason, we cannot avoid this reality, Bangladesh also. But at the same time, when all of our citizens, like rest of the world, enjoying the all facilities of social media, our people also enjoying all the facilities. But unfortunately, by this time, some vested corner who are always trying to use these facilities in the negative way and negative thinking. And it is not only happening in Bangladesh. All over the world, it's happening regularly. That's why from where the digital facilities started in like America or Europe or even Australia and others developed country, they are also all from all corners, all are raising their voice to control this media because the vested corner, they are who are saying this freedom of speech, they are misinterpreting the freedom of speech. There's been, in this subject, I would like to say like Bangla, এভাবে বলতে চাই যে freedom of speech মানে কি? Freedom of speech মানে কিন্তু আমার মন যা চাইবে তা নয়। Definitely freedom of speech মানে আমি একজন নাগরিক, আমি একজন মানুষ, সেই হিসাবে আমার অধিকারটি পরিপূর্ণভাবে সংরক্ষিত থাকবে। একজনের অধিকারকে খর্ব করে কথা বলা, লেখা কখনোই ফ্রিডম অফ স্পিচ হতে পারে না। একজনকে অযৌক্তিকভাবে অপমানিত করে, হেয় করে, অবমাননা করে বক্তব্য দেওয়া বা লেখা ফ্রিডম অফ স্পিচ হতে পারে না। কিন্তু দুর্ভাগ্যের বিষয়, আমরা মাত্র উন্নয়নশীল দেশের কাতার থেকে ডেভেলপড হয়েছি ঠিক, উন্নত বিশ্ব কিন্তু এই নেতিবাচক কর্মকাণ্ডগুলো সমানে চলমান। অতি সম্প্রতি জাস্ট গত পরশু 2 দিন আগেই অস্ট্রেলিয়ান পার্লামেন্টেও ডিজিটাল সিকিউরিটি অ্যাক্ট পাস হয়েছে বাস্তবতার নিরিখে, বাস্তবতার অনিবার্য সত্যের আলোকে। বাংলাদেশেও যার হাত ধরেই এই দেশটি ডিজিটাল প্রযুক্তির ছোঁয়া পেয়েছে, যার হাত ধরে বাংলাদেশ আজকে আমরা নতুন প্রজন্মকে অনেকগুলো ক্ষেত্রে ডিজিটালাইজড করতে পারছি, সেই ডিজিটাল বাংলাদেশের স্বপ্নদ্রষ্টা এবং রূপকার, এবং একই সাথে আমি তাকে মার্শাল বলতে চাই, যে এই ফিল্ড মার্শাল বলতে চাই, যেহেতু উনি কাগজে কলমে সেটি করিয়ে দেখিয়েছেন মাননীয় প্রধানমন্ত্রীর উপদেষ্টা সজীব ওয়াজেদ জয়কে। তিনি এই বাস্তবতাগুলো মাথায় রেখে বাংলাদেশেও মূলত নাগরিকের সম্মানের নিরাপত্তা, নাগরিকের আত্মমর্যাদাবোধের নিরাপত্তা নিশ্চিত করার জন্য ডিজিটাল সিকিউরিটি অ্যাক্ট এর পক্ষে কথা বলেছিলেন। কিন্তু দুর্ভাগ্যের বিষয়, সেই সময়ে অনেকেই এই আইনের প্রকৃত মিনিংটা অনুধাবন না করে এটাকে নেতিবাচকভাবে বিশ্লেষণ করে মূলত বাংলাদেশকে হেয় করার চেষ্টা করেছে। কিন্তু আজকের বাস্তবতায় খোদ আমেরিকা, খোদ ব্রিটেন, নিউজিল্যান্ডের মতো দেশ, তারাও কিন্তু এই ডিজিটালাইজেশনের যে নেতিবাচক প্রভাবের কারণে তাদের সোশ্যাল সিকিউরিটি বলেন, অর্থাৎ সামাজিক ব্যবস্থাটা অনেকটা ভেঙে পড়ছে, তারাও কিন্তু আইন করছে এবং আরো কঠোর আইন করার কথা ভাবছে। সুতরাং এই বাস্তবতার আলোকেই ডিপ্লোমেটস ওয়ার্ল্ড আজকে এই অসাধারণ একটি অনুষ্ঠানের আয়োজন করার জন্য আমি সকলকে ধন্যবাদ জানাচ্ছি, কৃতজ্ঞতা জানাচ্ছি, এবং আমরা আশা করব এইভাবেই আমরা সত্যিটা, অর্থাৎ এই ডিজিটাল সিকিউরিটি অ্যাক্টের বাস্তবতাটা আমরা একেবারে প্রান্তিক লেভেল অবধি পৌঁছে দিতে পারবো। সবাইকে ধন্যবাদ, শুভ সন্ধ্যা।
Thank you, sir, for your speech. Now, please, can we have a huge round of applause for inviting our chairperson, Mr. Junaid Ahmed Polok, sir, the State Minister for Information and Communication Technology, the Government of the People's Republic of Bangladesh.
Respected special guests, keynote speakers, ladies and gentlemen, friends from media, good afternoon to you all. Today we are here to talk about the state of digital security and legislations in Bangladesh. At the outset, I would like to pay my deep respect to the father of the nation, Bangabandhu Sheikh Mujibur Rahman, for whom we have got our freedom, we have got our independent Bangladesh. I would like to pay my homage to the 3 million martyrs in the liberation war who dedicated their lives for our freedom. Today, we are discussing about the fact and impact of Digital Security Act 2018. Not very long before, the people of our nation didn't have any concept as the cyber crime or cyber security. because before 2008, before declaration of the Digital Bangladesh Vision, our internet users number was so low. Only 5 million people were connected with internet. Only less than 40% people were enjoying the access to electricity. And if you talk about the digital connectivity or employment, digital government, ICT industry, financial transaction, all these progress happened in last 12 years after the declaration of Digital Bangladesh Vision back in 2008, 12th of December. The visionary leader, Honorable Prime Minister Sheikh Hasina, declared her vision to build Digital Bangladesh in 2008. And after forming the government in 2009, the main architect of Digital Bangladesh, Mr. Sajib Wazir Joy, under his guidance and leadership, we have been able to complete the vision and achieve all of our targets within last 12 years. Digital Bangladesh, we have built upon 4 pillars: human resource development, connectivity for all, ICT industry, and digital government. So after developing all of our digital infrastructures, we had some problems. We had some cyber attacks in our central bank, in different digital government services. You all know in 2016, there was a severe cyber attack in our central bank. And before 2018, we had no cybersecurity law. And I would like to just share some of the information regarding cybersecurity. The things has changed. Globally, 71 million people fall victim to cybercrime each year, while 887 million people's data are breached. Hackers attack people worldwide roughly every half a minute. This translates to a cybercrime being committed on an average of 2,224 times per day. Let me talk about the major effects. There is an interesting fact that if cybercrime itself was a country, one of these days it could have become the 3rd largest GDP in the world. Apart from the economic perspective, cybercrime rather have some long-lasting impact on the society and individual lives. Let me talk about the legislation overview. Commercial internet was introduced in 1983. In a matter of one single year, humanity had to introduce the first cybercrime legislation as Computer Fraud and Abuse Act 1984 in USA. So I'm just talking about the history, how this cyber world developed and how this cyber crime started and how the humanity had to explore and experience the cybersecurity law first time in 1984 in the USA. Now, when the internet is transforming global economy, triggering industrial revolutions, if we notice, we could find that 13 countries don't have any cybercrime legislations, while 1% nation has no data at all. So, what is our methodology? Nowadays, we follow specific methodology regarding legislations. We specify our objectives and scopes through strategic initiatives to identify the policy opportunities. Only after then, if we consider required, we initiate acts. We follow this strategy that whenever we need and require any kind of guidelines or law or strategy policy paper, we go first for strategy, then policy, then if required, we introduce law. That is the methodology under the ICT division under the guidance of Honorable ICT Advisor. The Digital Security Act 2018 can be reflected into 7 major components. Digital Security Agency established under Section 5, Chapter 2 of Digital Security Act 2018. National Security Council, chaired by Honorable Prime Minister, is formed under Section 12, Chapter 4 of Digital Security Act 2018. Emergency Response Team, Bangladesh Government's E-Government Computer Incident Response Team, BGD eGov CERT, currently serving as the National Computer Emergency Response Team of Bangladesh NCERT under Section 9, Chapter 3 of Digital Security Act 2018. And Digital Forensic Lab was established in 2018 under Section 9, Chapter 3 of Digital Security Act 2018. Let me talk about the local storage facility. We have ensured local storage of national data within our Tier 4 data center established in November 2019, which is the world's 7th largest government data center. As a continuity of progress, we have initiated many more strategies and policies for ensuring the safety of our citizens and for the nation. We have very young, competent human resources working in different teams and units to make sure the preventive measures are properly placed. We often receive criticism and responses regarding this law. I want to express that Digital Security Act does not prohibit any form of having individual thoughts and freedom to express. Moreover, it inherits the Article 20 of ICCPR and prohibits any propaganda of war or any advocacy of national, racial, or religious hatred, penalizing for expressions that merely affect the reputation of the country, government, or political party. And those who claim that the act is an instrument of political suppression, they must understand that the law says, according to the act, spirit of liberation war means the high ideals of nationalism, socialism, democracy, and secularism, which inspired our heroic people to dedicate themselves to, and our brave martyrs to sacrifice their lives in the national liberation struggle. Any kind of propaganda or campaign against liberation war, spirit of liberation war, father of the nation, national anthem, or national flag is prohibited. We must understand the father of the nation and the father of prime minister are two different concepts entirely. Exceptions and examples. Few media analysts suggested that some of the case references I'm giving you on this slide, so you can understand we have some references like only the Brandenburg versus Ohio is not only the one reference. There are many references from USA, from UK, or from different countries, from different courts, verdicts and references. We have to study those case references, then we can understand the global scenario. There are exceptional cases where Facebook helped spreading hate speech, which made us responsible for hosting more than 1 million Rohingyas. But should we consider these discrete events as examples and see Facebook as a weapon? Or shall we collaborate with Facebook to prevent these exceptional incidents from happening ever again? Applications so far in Digital Security Agency, so far Digital Security Act 2018 is being used by our citizens so that the government and law could protect them. And according to the law, trial is a must for any judgment. Our law doesn't sentence anyone without a fair trial, even when that person has committed any heinous crime. Our central bank, the Bangladesh Bank, has topped the national cyber drill among the 39 banks and financial institutions. Moreover, we are collaborating with them to establish country's first ever FinCert very soon. Bangladesh tops among all SAARC nations in National Cybersecurity Index. In August 2021, we gained 38th position, which is our best so far. Thanks to the legal measures scores we got because of the Digital Security Act 2018, we rank at the 11th position among all the nations of Asia-Pacific region. When we think about the internet, we imagine magical connectivity that gives communication opportunity to different people sitting in two different centers or corners of the world. But due to some shameful events of humanity, we saw this dream tearing us apart from the inside. We did a case study on one of the most popular incidents of recent times. A hoax about mass beating on suspicion of child lifting caused 22 deaths took place in India on 2018. The incident that took place in Bangladesh on 2019, a year later, is mass beating on suspicion of the child lifting because Padda Bridge requires human heads to complete its construction. This is how these propaganda and misinformations are engineered. Because one single incident changes their whole life and sometimes even ends it. I would like to close my presentation by concluding through some remarks. Security isn't expensive, it is priceless. Freedom of speech is often misused for freedom of reach to a couple of billion people. No technology that's connected to the internet is unhackable. Just like real life, we must consider security as a fundamental component of the system required to maintain order and ensure safety of our citizens who exist in virtual world. Cybersecurity is a basic human right, not an add-on. With this, I would like to conclude my speech. Let us build a safe and better world for our next generations. Joy Bangla, Joy Bangabandhu.
Thank you, sir. We are glad to have you. Now, please can we have a huge round of applause for inviting our chief guest, Honorable Minister Dr. Hassan Mahmood, Ministry of Information and Broadcasting, the Government of the People's Republic of Bangladesh. Sir is going to join with us virtually. Can we have a moment for sir, please?
Good afternoon to everyone. Honorable Chair of the session, the State Minister for Information Technology, Mr. Junaid Ahmed Palok, special guest, Attorney General, Mr. Aminuddin, other distinguished guests, ladies and gentlemen, and the people from diplomats. Good afternoon to everyone. It would be better if I could join physically in this session, but I was informed last night, I was confirmed in the last night that this event is going to be organized today. That's why it was not possible for me to be there physically. But as Digital Bangladesh has enabled us to participate anywhere from the world virtually, that's why I'm taking the opportunity to join the session virtually. I think it would be better if I speak in Bengali because there are many television channels. They would prefer Bengali. And if there are many foreigners, then I would continue in English, but I don't see any foreigner there. As I have been informed, there are no foreigners. So I'm going to speak in Bengali. Digital Security Act, যেটি নিয়ে আজকে অনেক আলোচনা হচ্ছে বাংলাদেশে। ডিজিটাল সিকিউরিটি অ্যাক্ট এটি বাংলাদেশের সব মানুষের ডিজিটাল নিরাপত্তা দেওয়ার জন্যই ডিজিটাল সিকিউরিটি অ্যাক্ট। যখন ডিজিটাল বিষয়টা ছিল না তখন ডিজিটাল সিকিউরিটি অ্যাক্টের প্রয়োজনীয়তা হচ্ছিল এবং যখন এই ডিজিটাল বিষয়টা বাংলাদেশে এসেছে পৃথিবীর অন্যান্য দেশেও এটি আজকে বাস্তবতা, তখন পৃথিবীর